Welcome to Chapter 1 for Employment Law. This chapter will discuss the regulation of employment. In this chapter of employment law, we're going to look at the regulatory environment of the employment relationship and whether regulation is necessary or beneficial, if the employment relationship is better with less government intervention or if there's more needed. We'll explore concepts of freedom to contract in this employment environment, non-compete agreements. And so we're going to look at a lot of the case law discussed in this text and look at the difference in classification between employers or employees. I have all these slides available separately on CourseDen if you want to look at them and follow along with this video to take notes, or if you just want to print them out and mark and highlight, whatever works for you. So these are the learning objectives for the chapter. At the end of this chapter, you'll be able to describe the balance between the freedom to contract and the current regulatory environment for employment that governs those contracts. You'll know who's subject to which employment laws and understand the implications of each for both the employer and employee. Look at those risks to the employer caused by worker misclassification. Explain the difference between an employee and a contractor, independent contractor. How do we decide who's who and make that determination? You'll also understand the various ways in which the concept employer is defined in those employment-related regulations and look at the permissible parameters of those non-compete agreements. As we get started with this employment law course, I want you guys to kind of think about your perspective and where you're coming from and what employment law really is or what you think it is before we even get started. How the law affects management in general is kind of what we're going to be studying here. And it's important for you to understand this as employees, maybe now, or potential employers. Even when someone doesn't always follow the law, you need to be aware of the ramifications of someone's employment decisions. For example, as an employee, someone might know that their employer doesn't have a right to do something, but the employer does it anyway, and that employee submits to avoid losing their job or having to go to court. As an employer, they may know that their actions aren't legal to the letter of the law, but they weigh the costs and benefits and maybe they decide to do something anyway. So understanding what the law is in order to weigh what's at stake and what the cost is really important as you study and learn more about these employment laws. The first thing we're going to look at is this freedom to contract, which is really important to the marketplace of employers. If an employer wants to hire someone who's going to work really strange hours, like every other hour, every other week, they should be allowed to do that as long as they can find the employee who wants to work that type of job. This freedom to contract is really important to the freedom of the market. An employee can choose to work or choose not to work for a given employer, and an employer can choose to hire or not hire a given applicant. It's important to remember this is kind of that baseline of hiring and employing and choosing where to work with that freedom that's really important. There are government laws that help offset power imbalances between employees and employers that set these things in place that regulate, minimum wage, prevent discrimination. But it's important that people understand, this freedom to contract is really important in the employment law context. So this brings us to the question of, is regulation necessary, or how much regulation is necessary? Market forces encourage non-biased behavior, and people who are making illegal decisions based on race or gender are inefficient. But employers also have this flexibility where they want to manage their companies as they see fit, but they can't go in against the law because they could create liability for themselves. So there are scholars that believe that regulation in these kind of areas of employment relationship isn't necessary, and then there are proponents that think that they're really important. Some people argue that people interested in maximum profit are not going to hesitate to hire the most qualified applicants regardless of other factors, but therefore they don't let prejudices cause them to hire anyone who's not qualified, and they employ an efficient workplace. However, the opposite position is that discrimination continues often because employers are faced with a choice of two equally qualified applicants, and sometimes prejudiced behavior comes into play where they choose one over the other. In addition, human beings don't always act rationally. They don't always follow logic. There could be, economic forces at play. If there's a bias there, they don't afford absolute protection against employment discrimination, but the law does protect against employment discrimination based on race, gender, national origin, and these other protected categories of workers. Now, the reality about the regulation of the employment environment is that generally no one has a right to their job. An employer can choose to hire or fire someone even for reasons that seem unfair, unjustified, as long as it's not a violation of the law. So there are far more reasons that someone could get fired than there are reasons they would not get fired. Someone could get fired just because they don't like working with this person or it's just not a good fit, but it's important to ensure that bias or prejudice is not that basis of someone getting fired, because that can cause a claim for discrimination, and that's not interfering with someone's judgment. And when it comes to employment law situations, classification of workers is really important. So the origin of worker classification comes through the law of agency. It's based on this traditional law of master and servant, which evolved into this law of agency. In employment agency relationships, the employee has this specific duty to the principal to act as authorized. So if they go beyond their authority, they could place the principal at risk without having the proper authority. The principal is now responsible to the third party for loss or damage resulting from the agent's unauthorized act. Through the entire relationship, the principal, the employer, has the obligation towards the agent to exercise good faith in the relationship, and the principal has to use care to prevent the agent from coming to any harm during the agency relationship. This requirement translates into the employer's responsibility to provide a safe and healthy working environment for their workers. But it's important to determine whether a worker is an employee or an independent contractor, because the law classifies them differently and there's different requirements. So the two classifications are someone who is an employee versus someone who is an independent contractor. An employee is treated different under the law and has different protections than someone who's classified as an independent contractor. This definition becomes increasingly important as companies sometimes hire temporary workers, contingent workers, supplemental workers on an independent contractor basis to kind of cut costs. Generally, an employer's responsibility is greater when someone's an employee than if they are an independent contractor. So even when these protections come into play for discrimination protections, the Civil Rights Act under Title VII, it applies to employees, not to independent contractors. When it comes to taxes and payroll deductions, those are treated differently. With an employee, they are sending those tax withholdings directly to the government, whereas independent contractors, they're responsible for filing and paying their own taxes and deductions. Employees sometimes are eligible to receive more benefits, and usually an independent contractor doesn't have access to those benefits. But some companies, why would they want to use independent contractors? Well, sometimes they need an intermittent need. Someone comes in as an independent contractor for a specific purpose or a project, or there's cost factors at play. There's differences for liability. So you can see here on the slide, there's benefits for someone wanting to do an independent contractor, but there's a problem because some people misclassify their workers and the stakes are really high. Inaccurate classification of workers comes with really heavy fines and penalties. If someone is classifying something as an independent contractor position, but it really is an employee position, that employee is missing out on maybe protections and benefits, and the employer can get in a lot of trouble for this intentional misclassification. The IRS has a safe harbor provision, so if the employer has always and consistently classified a group of workers as independent contractors, there's 4 criteria to claim a worker as an independent contractor. When these conditions have been satisfied, the employer is not liable for the misclassification. So these 4 situations are, the business never has treated that worker as an employee for the purposes of employment taxes. All the federal taxes with respect to this worker were filed consistently with them being treated as an independent contractor. The company's treated all those in positions similarly situated as independent contractors, and the company has a reasonable basis for treating this worker as an independent contractor. And then in 2011, the IRS introduced this voluntary classification settlement program. So if employers are not currently subject to examination by the IRS, the Department of Labor, or some other agency, they can voluntarily reclassify their workers to obtain substantial relief from federal payroll taxes, interest, and penalties, as opposed to people who are subject to fines and penalties for misclassification. In both programs, the employer must agree to treat workers as employees in the future. So let's look at the definitions of employee. So there's been various ways to define whether a worker is an employee. Generally, the interpretation used depends on the circumstances and facts presented by each individual case, as well as the law that's at issue. Several tests have been developed and are commonly used by courts to classify employees as independent contractors. These tests include the common law test of agency, which is the most common, and has several factors but focuses on who has the right to control the work. And some courts also use a hybrid approach, one test that combines the factors from the other tests. The IRS uses a 20-factor analysis and the economic realities analysis. All three tests are functionally equivalent with the common law test controlling. It's also important to look at other non-traditional work relationships. Think about temporary workers or contingent workers. There's people that do gig work as like side hustles. There are some unclear rulings that are coming through the pipeline with courts considering, gig workers. There's a lot of people who are classified, as independent contractors in these gig economy, and yet could really be hurt by not having classification as an employee. So there's lots of things that are being considered right now in the court. So it's kind of unclear with where this might go in the future. But you want to think about, these contingent or temporary situations, whether they're employees or contractors, with work that's temporary or happens occasionally, that's different than, being a full-time employee that comes to work every single day. Staffing agencies that provide workers here and there as needed, but then they have their own people that they act as the employer to those people that are registered with a staffing agency. So there's a lot of continued uncertainties around some of these other gig jobs. Think of rideshare drivers, Uber drivers, Lyft, and that kind of stuff for a hybrid classification potentially, in the future. We also have situations with trainees, interns, volunteers. If someone is working as a trainee, they're exempt from FLSA minimum wage and overtime while they're receiving their formal training. Interns, we look at that primary beneficiary test. It determines if they're paid or unpaid. There's factors, is this for education purposes, commercial elements of the relationship as they're learning the job. They want to make sure that FLSA rules are being followed where they're appropriate to apply. Volunteers, people that work as say a volunteer firefighter or something, they're unpaid workers doing public service or maybe religious service or humanitarian aid, those kind of things. And then it's important to know whether a staffing agency or a client bears the contingent employment burdens with potential liabilities and those things. So staffing firms could be an employer, the workers being paid by the agency, and then the company that needs more staffing will pay the staffing agency. The staffing agency is the one who pays the actual worker. They provide training and placement, and they provide the workers' compensation coverage. The client could be joint employer, looking at different factors, joint and several liability of both firms in that situation, who has the power to do who does the training, who has the power to hire and fire, who's providing the supervision, who's setting these terms. And so it's important to look at the details of these cases and coverage of applicants. So workers who seek employment are protected from hiring discrimination. When must hiring documents be retained by employers? Federal regulations, often require applications be tracked based on race, gender, ethnicity. It's important to have a clear and consistent definition of who's truly an applicant. According to the EEOC, the precise definition kind of depends on the employer's recruitment and selection, but in general, it's going to be individuals who indicate an interest in being considered for hiring, promotion, or other employment opportunities. This interest might be expressed by completing a written application form or by expressing interest orally, depending on the employer's practice. Technology has changed the way that nowadays we apply for jobs. It's also raised questions about who's truly an applicant in this age of the internet. Currently, the U.S. Department of Labor, there's 4 criteria that define who's an applicant. And, we're looking for someone who submits that expression of interest for a specific opportunity. The employer considers that person for such an opportunity. That individual expresses of interest indicates that they possess those basic qualifications for that position, and the individual does not remove themselves from consideration, saying like they're no longer interested in that position. And so thus it's a little bit more than just sending an email inquiry about a job. That's not going to qualify the sender as an actual applicant. Same thing with posting resumes on a third-party job board. That's not quite enough to reach that criteria to be an actual applicant. So here are some management tips for you as you go into your future careers. When it comes to classifying someone correctly, what is their worker status? Understand these inherent difficulties and important consequences of making sure you get the right classification for your workers. It's great if you have a written agreement of what their classification is going to be, so that it's clear that both parties understand why they're being classified this way as an independent contractor or as an employee. If the employment is contemplated, indicate like this is going to be for a contract period of this amount of time, or whether this is at will employment. If this is contemplating independent contractor status, articulate like who's in control and outcomes anticipated, deadlines preferred over set hours of working this day at this time. You maybe specify responsibilities of who's responsible for taxes, expenses, materials. It's nice to have that stuff in writing so it's clear that everybody understands. Preferable to send the payment for your independent contractors for the results they're giving rather than clocking the hours and time that they've spent. Of course, it can be different for different situations. These are just some kind of general guidelines. Employer-provided training is a strong indication of someone having employee status as compared with someone who brings their own knowledge and skills and training to the table for an independent contractor. They hire their own assistants. So if someone's hired for a job, an independent contractor might bring their own assistant, their own helpers, their own workers. If the question is kind of close, maybe it's important to seek legal advice or look at other rulings and definitions, to try to figure out that you're classifying workers appropriately. And remember, like, the writing is important, but the actual performance is really what's going to be looked at to make sure there's proper classification. The writing is important so we have clarity and understanding on both sides, but training oversight of the relationship may exist in either situation. It's just important that the actual performance indicates that it's the proper classification. So again, defining employer. This is important to know who's got to comply with the laws and what those laws are. So we spent a lot of time talking about the classification of the workers, whether they're employee or independent contractor, but it's also important how we defined who the employer is and who's the person that needs to be in compliance with the laws. Depending on the applicable statute or provision, employer is simply one who employs or uses others to do their work or to work on his or her behalf. Most states specifically include this definition in employment agencies, labor organizations, joint labor management committees, and such. But issues can arise when there's an entity that claims to be a private membership club. Remember, we have Title VII prohibitions that exist in this context, or a multinational company that may or may not be subject to the application of certain U.S. laws. We have a determination that might be made when an employer receives federal funds or maintains federal contracts for coverage under the Rehabilitation Act of 1973, among others. Another question is whether an individual, like a supervisor, is also considered an employer under employment-related statutes and therefore can be held personally liable for his or her actions. Though most states are silent on this issue, the majority of courts have concluded that federal anti-discrimination statutes do not permit the imposition of this liability. So the most exacting issue is usually going to be how many employees an employer must have in order to be subject to a given statute. We see that different statutes apply when you have 15 or more full-time employees that work 20 or more weeks. We have some statutes that apply to 50 or more employees, so that's an important consideration when we're trying to decide which statute might apply to a certain situation. It's crucial for employers to be familiar with the statutes that they are subject to and which statutes they might be immune from. I have a note here also that you need to also consider that some states have similar laws that have lower size thresholds. So in this course, we're covering federal law and talking about what states do generally to give you that foundation, but it's important when you enter your careers to make sure you're aware of what the state law is that you're practicing in. So like Georgia law in addition to federal law, if you're here in the state of Georgia, for example. So one employment constraint that's received varying degrees of acceptance by different states is this covenant not to compete, or when people have non-compete agreements. Individuals in position of trust and confidence already owe a duty of loyalty to their employers during employment, even without a non-compete agreement. And a non-compete agreement usually includes prohibitions against disclosure of things like trade secrets, soliciting the employer's other employees or customers to go work at another place, entering into competition with the employer if the employee is terminated, things like that. It's a powerful deterrent to someone switching jobs and going to work for the competition or becoming the competition. And there has been some discussion on the federal level about what is or isn't appropriate when it comes to non-competes. FTC proposed a rule in 2023 that would invalidate most non-compete agreements. Many states restrict or prohibit certain things in non-competes when it comes to employment context, because there's generally a public policy to not discourage worker mobility, that because people have the right to choose who they work for and where they work, that is a right that is generally protected in a lot of states. And other states that do enforce non-compete agreements might limit coverage based on particular professions or making sure that the terms are reasonable. So, terms that say you can't go work for a competition that's right across the street or within this certain, small area of miles or distance or this particular zone is going to be more reasonable than someone who says you forever are prohibited from working anywhere in the country in this type of industry, because that's just not reasonable. That's where someone's expertise and experience is, and so it's completely unfair to prohibit them from ever working for someone else in that industry. So let's look at the things that would be considered valid in a non-compete agreement. Again, non-compete agreements are important to protect legitimate business interests. And so a lot of states allow employers some control over what information a former worker can use or disclose in a competing business, whether a former worker can encourage clients, customers, other coworkers that they used to work with at that employer from leaving and coming to this competition. But it doesn't need to be more broad than necessary to protect those interests. And is it reasonable in those prohibitions that it has when it comes to length of time and distance and territory that it's preventing someone from competing against this original company? So a non-compete that is contrary to public interest is not going to be enforced. At the common law level, a non-compete agreement that's going to be prohibitive if the restriction is more broad than necessary. It's important that it's reasonable, that it's not more broad than necessary to protect the employer's legitimate business interest, or if the employer's need is outweighed by the hardship to the employee and likely to injury to the public, it's not going to be enforced. To determine reasonableness, a court's going to look, at those specific details to decide whether it's okay or not okay to enforce this. And of course, these are important to protect trade secrets. Employers have an interest in making sure that things they've worked really hard as a trade secret is protected. So confidential information or things they've learned about their customers over time with doing business with them. Non-disclosure agreements, NDAs with key employees, should always include trade secrets coverage. That's really important to protect the privacy of those intellectual property situations. And then Uniform Trade Secrets Act in most states discourages the misappropriation of trade secrets. Leaks happen, they just do. But the employer's intellectual property is protected with these laws. Under the UTSA, this Model Act strives to provide guidance to states as they're developing their individual state statutes. to this kind of area, and they provide relief in the form of monetary damages, attorney's fees, injunctive relief for misappropriation of trade secrets, and also includes a provision for inevitable disclosure. And it's important to remember, as we move on to the chapter summary from non-compete agreements, if a non-compete agreement has been found to be valid, in order to be enforceable, it's got to be supported by consideration. Think back to your legal environment of business class, and we learned that one of the essential elements of a contract that is a legally enforceable promise is the agreement has to be supported by consideration. There's got to be to show that bargain for exchange. So an agreement by an employee not to compete with the employer is only enforceable if the employee also received something in exchange for this agreement. Often non-competes are signed at the time the employee is first hired. So the offer of employment on its own can be considered sufficient consideration. However, if an employee is asked to sign a non-compete agreement after they've already been hired and they're not offered any additional compensation or some kind of benefit, then there's no consideration, and some states won't treat continued at-will employment as sufficient enough to be legal consideration. It can depend, again, on the state where it was signed, but that's important to consider if you're coming from the employer perspective and you want a valid non-compete agreement. You've got to make sure there's consideration. So in summary, any size business that has workers is subject to all these regulations, and there's important risks to be managed if someone is not following a regulation or knowing whether or not they're required to follow this particular statute or this particular regulation. It's important to be careful how workers are classified, because misclassification workers can have severe fines and penalties. Whether or not someone's an employer, that status consideration is important to see how particular laws are going to apply in that situation, and knowing the enforceability of whether your non-compete agreement is enforceable or not is really important to consider how those intellectual property interests are going to be protected. Some tips for management tips for your future career. Make sure that you're careful how you classify workers, because those mistakes can be really expensive. Hiring an independent contractor is not a safe harbor from liability for misconduct. If you're hiring someone as an independent contractor, it's important that they're being classified properly. If a staffing firm contract, it needs to be carefully negotiated to clearly spell out responsibilities and covered risks if you are choosing to work with a staffing company for temporary employment needs of workers, and understanding your state's enforceability of non-compete agreements. Is it reasonableness in this non-compete? Like, is the territory covered or the time that it's in place for, is that going to be reasonable? That varies from state to state, so it's important to consider in the states that your company is working with. And if you are going to compose a non-disclosure agreement, an NDA, those need to be carefully composed as well, just like non-compete agreements. So again, think back to your contract law and the statutes that apply in these situations. And that's the end of our Chapter 1 lecture. Again, you can review these PowerPoint slides separately on CourseDen, and if you have any questions, send me an email and let me know.